So, finally, let's come to a critique of negative integration as a mode of creating the internal market. The key issue here, and this goes to more general opposition to the EU and opposition to free trade and trade liberalism, which has been associated with populist movements, as touched on by Bogan in his lectures. The key issue here is, where is the space for nationally determined values? Since the Single European Act represented a huge step, a step change in terms of opening up of European markets, the member states' autonomy in a range of issues, especially in cultural matters and welfare issues, was no longer secure. As the single market became almost a goal in itself, it was possible to argue that many other policy objectives represent non-tariff barriers to trade, measures having equivalent effect to quantitative restrictions in the language of EU law. And as such, those policy objectives and the laws and administrative practices in which they are embodied violate the logic of the single market. Consequently, the European Union has been able to vastly expand the scope of the single market at the expense of the autonomy of member states to pursue their own policies, in particular in social and welfare contexts. According to Fritz Scharpf, the European Court of Justice's role in this process is usually neglected by the literature explaining the success of the reforms. The Court of Justice's early case law paved the way for a future reconfiguration of the original balance between economic freedoms and social rights in the EU's constitutional settlement. Scharpf argues that the court's rulings in two early cases, the Dassonville case in 1974 and Cassis, which we've just looked at, crucially limited member states' discretion in formulating national policies and announced a new rule of mutual recognition, which has changed the bargaining constellation and the incentives for action between the different constituent parts of the European Union's constitutional order. People like Gareth Davis and others argue that the European Court of Justice's restrictions analysis gives primacy to the economic freedoms and creates a presumption that a national rule is unlawful. What this does is it puts the defendant, which is usually the state, on the back foot, having to defend national policy choices and show that the legislation is justified and proportionate. We're going to look much more at this next week and in the weeks that come. So let's start trying to draw this all together. You should by now have a good overview of how law shapes the European Union's internal market, and the rest of the module is concerned with filling this in much more detail. And you should also have some added perspectives to some of the questions and subjects covered already earlier in the module: the importance of the constitutional qualities of EU law, its supremacy and direct effect in particular, the competences of the EU institutions to adopt legislation. And we've also linked up the internal market legal principle of mutual recognition with concepts that you met earlier, like national sovereignty and transnational law. And we've started a running theme about how economic integration through law, with all of the benefits, the undoubted benefits that brings, can be seen in opposition to national regulatory autonomy, which protects values other than the economic. And we've started this theme of thinking about how the EU's economic constitution, embodied in the treaties as interpreted by the European Court of Justice, is kind of encoded so as to push European Union member states towards deregulation, or as Steve Wetherill puts it, a bonfire of red tape. The push of negative integration and of union market competences is not compensated by equal union competence to secure other objectives, perhaps those kinds of objectives more supported by European populations. And this reminds us of the earlier theme of the European Union being caught between a rock and a hard place in terms of its legitimacy, with insufficient power to do the things that the populations of its member states might want, but constrained by the limited competences enshrined by those very member states in the treaties. As we go through the rest of the module, you'll be wanting to reflect further on these themes, and in particular on whether this way of thinking about it, that there is a clash between these two different values, the economic and the social, is really a sufficiently nuanced and sophisticated way to account for the details of the law that we will be studying. And in that regard, I just want to leave you with a final thought from Catherine Barnard, one of the professors of EU law at the University of Cambridge. So Catherine, on these topics, argues, it would be a mistake to conclude that in Cassis the court favoured free trade to the detriment of broader interests which are valued at national level. The development of mandatory requirements not only places a brake on any possible destructive regulatory competition, a race to the bottom, but also recognises that the European Constitution is not merely economic, but pluralistic, a constitution that embraces social and cultural values. There'll be more on this in the weeks that come. For now, keep going with your independent work, enjoy your operating teams, and I look forward to meeting you all either in person or online in the tutorial soon, and at any time that any of you would like to do so in a one-to-one context. Take care.